All right, hi, welcome back, Attorney Steve Vondran, and welcome to another exciting episode of Copyright Watchdog. Today, breaking news, United States Supreme Court coming down with a copyright infringement ruling. Let's take a look. All right, so we're over here, we're talking about the case of Warner Chappell Music versus NEALY. All right, this is a very interesting story. So back in 1983, two guys got together, two artists, Sherman Neely and Tony Butler. They got together, they created the Music Specialist Inc. They created a company, they cut out an album, they cut out a few hit singles, this, that, and the other. I shouldn't say hit singles, they cut out some singles, and a few years later they disbanded, so forth and so on. So then what happens later? Over here, Neely ends up with two prison stints for drug-related offenses. The first one in 1989 to 2008. Next one in 2012 to 2015. Unbeknownst to Neely, Butler did not go anywhere. He continued in the business and he licensed some of the works from the catalog, some of the works from Music Specialist Inc. catalog, to Warner Chappell Music. All right, and next thing you know, I printed it out here. Let's take a look. One of the songs was called Jam in a Box, and this ended up being used by Flo Rida. Hit song In the Ire. And this sold millions of copies and made it up to number 9 on the Billboard charts. And the song was also licensed to TV shows such as You Think You Can Dance. Well, that's pretty good use of the song here. And other songs linked to Black Eyed Peas and Kid Sister. All right. So this creates an interesting question. Neely gets out of jail in 2016. Okay, he gets out of jail. He says, whoa, I didn't know all this was going on. I just discovered copyright infringement. I am a co-author of the music here. I am a co-copyright holder of the music. You can't just go license it and then not pay me royalties. What the heck, just because I'm in prison? So anyway, he discovers this in 2016. He files a suit within 3 years, which is what you need to do. It's statute of limitations is 3 years from the date that claim accrues. This is under 17 USC 507, B as in basketball. All right. So the claim accrues in 2008. There's a split of authority across the circuit courts in the United States. Some say the claim accrues accrues when the cause of action accrues, and you have 3 years. It doesn't matter when you discover. You better figure it out. If you don't figure it out, too bad. Other courts say, well, no, it's the discovery rule. It's when you know or should have known through the exercise of due diligence that you had a claim. Here, Neely is saying, well, here, I'm in the 11th Circuit Courts. We follow the discovery rule. And this Supreme Court decision, by the way, did not change the discovery rule. There is still the split of authority where some states say you must bring it within 3 years. Other states say it's 3 years from the date of discovery, okay? Anyway, so check your jurisdiction on that. This case did not change that. So he finds out, he files suit within 3 years. Warner Chappell argues, well, okay, the discovery rule applies in the 11th Circuit. Fine, we're not going to contest that. But we're going to say that he can't go back and recover damages back here in 2008, 2009, 2000. That's past the 3-year statute of limitations. The Supreme Court said no. Just because it's going back over 3 years, you can still recover those damages. Why? There's no bar in the statute, in the copyright damages statute. Did I put it up here? I think it's 17 USC 504. There's no limitation on how far you can go back for your damages. So the Supreme Court said, we cannot apply a rule that bars damages going back. If you found out in 2016 and you file timely within 3 years, you should be able to go back and recover all your damages. Otherwise, what good is the discovery rule? Because many times it's going to be outside the 3 windows anyway, the 3-year window anyway. So it would gut the discovery rule, the court said. So again, the court did not decide whether the discovery rule applies or whether the when the cause of action accrues, 3 years applies. But if it's 3 years, obviously you can only recover for those 3 years. This court said no. The 11th Circuit, it was conceded by Warner Chappell, follows the discovery rule, and the court said you can go back over 3 years to recover your damages. United States Supreme Court, law of the land, there you have it. This is general legal information only, not legal advice. Feel free to share this video. Don't forget to subscribe to keep these great videos coming to you. Have a great day. Have a great week, everybody. Attorney Steve, gotta run. Bye now.